Hello, my name is Erick Kaardal, and I am an attorney that has just filed a very important lawsuit involving Mille Lake and its walleye fishing. I represent Save Mille Lacs Sports Fishing, Proper Economic Resource Management, otherwise known as PERM, Twin Pines Resort Incorporated, Bill Eno, and Fred Daly. These persons and organizations have sued the Minnesota Department of Natural Resources for mismanagement of Mille Lake walleye fishing heritage. Now, what do I mean by fishing heritage? Well, you would know what I mean by fishing heritage. Mille Lacs is a very important lake in Minnesota, the second largest lake in Minnesota, and has a tradition, a custom, and a heritage of walleye fishing. This is no surprise. People travel all over the nation to come to Mille Lacs to fish walleye. That lake is a fantastic fishery habitat for walleye. It's always been known for walleye. The lake is the capital of walleye fishing for the whole world, and we all know Minnesotans love their walleye. The DNR has marketed the lake for walleye fishing for decades. Now, that's all changed. The DNR in the last 10 years, if it had devised a plan to destroy Mille Lake walleye fishing, it couldn't have done a better job. I mean, it's extraordinary how the DNR set out to replace this positive culture for Mille Lake walleye fishing, a culture where families gathered to plan their trips up north. They planned their trips to go to Mille Lacs to catch walleyes. They would do it as a family, as a tradition, as a custom. The whole lake would be abuzz and so forth. It's all been destroyed by negativity, by DNR administrative mismanagement. So what is this lawsuit about? Well, the lawsuit is about restoring Mille Lake walleye fishing heritage. Now, why do I use those words? Because the key to understanding this lawsuit brought by these organizations and people is that the Minnesotans in 1998 passed a law, a constitutional amendment, that preserves Minnesota's hunting and fishing heritage. It was the Hunting and Fishing Heritage Preservation Amendment. It was passed, with a great number of votes, a supermajority, over 80%, if I recall. And what it says precisely, this is Minnesota Constitution, Article 13, Section 12, adopted November 3, 1998. Preservation of hunting and fishing. Hunting and fishing and the taking of game and fish are a valued part of our heritage that shall be forever preserved for the people and shall be managed by law and regulation for the public good. My clients in this lawsuit filed in the Minnesota Court of Appeals challenged the DNR regulations regarding Mille Lacs fishing because it violates this constitutional requirement. The DNR is required, when it passes its regulations, to consider and take into account this requirement. And that requirement is to preserve the people's fishing heritage. And that would include Mille Lake walleye fishing heritage. Instead of preserving it, the DNR over the last 10 years has destroyed it. As I said, it couldn't have developed a better plan to do it. You had this positive culture, now it's been completely destroyed and replaced by a negative administrative culture, and people are no longer traveling hundreds of miles to get to Mille Lacs. They're not traveling from the Twin Cities to fish Mille Lacs because the walleye population has been effectively reduced to a point that it can't maintain that fishing heritage. Now, it's important to also note that when the Minnesota people adopted that constitutional requirement to preserve fishing heritage, that Minnesota had already recognized a public trust doctrine. This is a very popular idea brought up by the environmentalist community nationwide in the 70s and 80s. And the idea with the public trust doctrine was that the power of the state to regulate a natural resource was limited by its obligation to the people to use that public resource for the benefit of the public. The government in the United States is not sovereign to the point that you can shortchange the public. You can't ignore the public interest. In the United States, the government must always consider, when managing natural resources, what's in the best interest of the public. Minnesota courts adopted the public trust doctrine, so it applies to every place in Minnesota and also to Mille Lake. So what does that mean? Well, it means that when the DNR is managing Mille Lake, it can't just look at the public and say, well, we have the right to manage it without regard to your public interest. No, the DNR must manage Mille Lacs Lake with respect to the public interest. Now that involves a lot of discretion, but a lot of that discretion was taken away by the 1998 constitutional amendment. You have the public trust doctrine saying Mille Lacs must be managed for the public interest. Then you have a very specific constitutional requirement that the fishing heritage be preserved. And the fishing heritage that preserved here was the Mille Lacs Lake walleye fishing heritage. That was the basis for the community, the basis for that heritage. So what happened at Mille Lacs over time was that the DNR has mismanaged the fishery, and as a result, we don't have enough walleye to be caught. People won't go to the lake anymore because there aren't enough walleye due to DNR mismanagement. In fact, to use a phrase, extirpation, you could say that right now the fishing heritage is extirpated at Mille Lacs Lake. In other words, the walleye fishing heritage is extinct at Mille Lacs. There isn't anymore. If you get together and talk about walleye fishing at Mille Lacs, you get negativity. There's no excitement and optimism about walleye fishing at Mille Lacs. When the DNR adopted these recent rules that were published on April 21st, 2014, they failed to consider either the public trust doctrine or the hunting and fishing preservation requirement, the amendment to the Constitution. So what happens when you have a rule, when an agency doesn't apply the right legal standards, is the rule needs to be thrown out. And so we're asking the Minnesota Court of Appeals to throw out the DNR rule regarding fishing on Mille Lacs this year, this 2014. So what will that mean for the fishermen? The fishermen will then be stuck with the old rules, which we're not proud of either, but at least we'll have night fishing after June 10th on Mille Lacs. This year's rules ban night fishing throughout the year, which is a variance from previous rules, and at least we'll get that peeled back. But with respect to what happens next, what we'll have to do is have more litigation, but this time when the DNR considers what the rules are going to be for fishing on Mille Lacs, you'll have to consider the people's tradition with respect to fishing. So what do the people expect on Mille Lacs regarding fishing, regulation, walleye populations and so forth? All of that matters because of the Fishing and Hunting Heritage Preservation Amendment in the Minnesota Constitution. The DNR has to explain in its report and analysis what the people's heritage is, and then must regulate the lake according to that heritage. Right now, the 10 years of mismanagement looks like the DNR has been trying to destroy that fishing heritage at Mille Lacs Lake. What we're not trying to do is switch the paradigm. We're going to come in and we're going to say, this is the legal standard. You have to manage to the people's heritage. You can't destroy that heritage and try to create a new heritage. In other words, Mille Lacs is the crown jewel of walleye fishing. It is the capital of walleye fishing. And despite the best efforts of the DNR the last 10 years, we're not giving up on that. We're going to fight to keep that status for Mille Lacs Lake, and that's what this lawsuit's about. And the courts can help by redirecting the DNR to appreciating, studying, analyzing, and trying to preserve the Mille Lacs Lake walleye fishing heritage. There are other cases which should support us. For example, in the public trust doctrine, there's a famous case out in California called the Mono Lake case. It's a landmark case. And there, they use the public trust doctrine to, the California Supreme Court used the public trust doctrine to support one lake. It was an important lake. It was a subalpine lake. It was a lake with incredibly sensitive habitat. The threat was all the water was going to be drained off by the city of Los Angeles. And the California Supreme Court came in and said, no, one lake is important enough under the public trust doctrine to protect. So similarly here, we're saying, look, the walleye is Minnesota state fish. More walleye is consumed by Minnesotans than any other state in the United States. We have a tradition, a heritage of going to Mille Lacs and catching walleye. It's part of who we are. And here the DNR over 10 years has tried to destroy that. And what we're trying to do is restore it. And we have the law to do it because we have the public trust doctrine, we have the Fishing Heritage Preservation Amendment. Those are the legal standards, and the DNR has completely ignored them for 10 years. They would rather change your tradition than honor your tradition, and that's what the constitutional requirement does not allow. Now, the DNR is going to come up with a lot of science. They're going to say, they've been trying and so forth. Don't believe them. They're not telling you the truth. If they had tried, then we'd have a fishing heritage. But that fishing heritage has been destroyed because they haven't tried. They're not telling you the truth. They haven't used science to manage this. Their science has been the opposite of science. It's been politicized. They've been making excuses. They know what's required to preserve our fishing heritage, but they deny our fishing heritage. They deny there have been consequences to the fishing heritage. They won't implement a plan to restore the fishing heritage. They won't even acknowledge your fishing heritage. For all they care, you could catch rough fish. No, the walleye is important to maintaining this heritage for so many reasons, and you know those. So when we go to the Court of Appeals and have our oral argument, we'll be arguing that the rule adopted by the Department of Natural Resources did not apply or even mention the constitutional requirement to preserve your fishing heritage on Mille Lacs. Didn't even mention it. So they didn't mention it. How could they have considered it and applied it? Because if they had applied it and really looked at your fishing heritage with respect to Mille Lacs, they would have acknowledged they failed. But that acknowledgement of failure is the first step to creating a normal relationship between the Department of Natural Resources and all Minnesotans. Because if they have acknowledged they failed and are destroying your fishing heritage, that'd be the first step to restoring that fishing heritage. And we can work together with the DNR to accomplish that. But it would require them to understand and to appreciate that they have to fight to keep our fishing heritage. And the American Indians would agree too. The Ojibwe tribes, they would agree that heritage includes walleyes on Mille Lacs. This isn't a zero-sum game. If there's a tragedy of the commons here, that tragedy of the commons does not include the story that's typically told, and that is overzealous fishermen taking all the Atlantic cod, not considering what's going to happen next year, and the government has to step in like a guardian angel and regulate everything so there's cod next year. No, that's not what happened here. The regulations were all working at Mille Lacs. It was just going fine. The people were happy. There was a heritage. And then the DNR started, after the treaty management case, started using the wrong models, the wrong science, cutting the wrong kind of deals with the American Indian DNR and Gliftwick, and it all went awry. And that was okay with the DNR, and the result was a destruction of Mille Lacs Lake walleye fishing heritage. That's not all right. That's a violation of law. So here the tragedy of commons was caused by the state agency. Error, error, error. We have to reset. You don't just keep pounding your head against the wall when a state agency is screwing up. You got to reset, and that's why we're going to the Court of Appeals and say, Court of Appeals, you reset the DNR because they won't even acknowledge their own failures. We've gone this far down the road, and they won't recognize that they've destroyed a fishing heritage. This is a great calamity for Minnesota, Minnesota fishermen, Minnesota families, Minnesota culture, the state of Minnesota. But it's about that culture. People want to be involved in that culture, and they've lost it. With respect to the next steps in the lawsuit, what we're going to be doing is we're going to be scheduling a hearing in the Minnesota Court of Appeals, and we're going to ask the Court of Appeals to throw the rule out. We think that'll occur in the next few weeks, and we should stay tuned to watch it. This is a very important case and has implications for hunters and fishermen for decades to come. It's right out of the box. It's brand new. It's a constitutional requirement that's been around for 15 years, hasn't been utilized yet, but if we use it correctly here, we can use it in every part of the state to protect the fishing and hunting heritage of all of us. Thank you.